All right, everyone. Welcome to the Yountville Chamber of Commerce 2025 Labor Law webinar. I'm Whitney Diver McAvoy, President and CEO of the Chamber of Commerce. Thank you so much for joining us. We are joined today by Jennifer Douglas, who is a partner in the Employment Law Division at Dickinson, Peatman and Fogarty, or DP&F. We are so excited to have her here today with us to share with you all of the important labor laws that we need to know for 2025. Jennifer has been a lawyer for over 25 years and has extensive experience in all manner of employment issues, including wage and hour and discrimination, reasonable accommodation, leaves of absence, and implementing state and federal regulations. So she's a tremendous resource for us here at the Chamber, and I know for many of our members throughout the Valley. So we're very thrilled to have her here today. We will have time for some questions at the end, but if you have a burning question that you can't wait to ask, you can drop it in the chat while the webinar is going on, and we'll go ahead and take a minute and ask that of Jennifer. So Jen, I'll go ahead and turn it over to you, and then we'll get started.
Okay, great. Thanks, Whitney. I really appreciate it. As Whitney said, I am the head of the employment department at DP&F, but I do not do it alone. My team, we have a team here that helps our clients navigate the difficult issues of employment law. Some of you may have worked with us. Kelly is our assistant, who is extremely valuable in everything we do. Marissa is my partner. Christina is our HR consultant, and we work together as a team so that we can answer all of your burning questions, because as you all know, employment law happens very quickly and you can't always plan for when you're going to have a problem or a question. So going on to our presentation, I just want to get a few things out of the way. I'm a lawyer, so of course I have disclaimers. This is all informational to you. It's not intended to be legal advice. So although we will take questions, this session is not intended to be legal advice, and there's no attorney-client relationship between you and DP&F. As from this particular webinar, I know that some of you are clients, so this is not considered advice through our relationship. The content is meant to be informational purposes only. Humor. Oh, go ahead, Whitney.
Oh, sorry, Jen. I'll let you go ahead and share your screen if you want to bring up the presentation.
Oh, is it not sharing?
It went away quickly, but...
Oh, it says I'm sharing. That's weird.
I'm able to see the disclaimers page.
Oh, you are? Okay.
I can see the disclaimers page.
Oh,
Okay.
Good. Okay. Well, maybe
it's just yours, Whitney. I'm sorry.
Okay. No, it's just me. Okay, guys, that's the best scenario, that it's just me. So we're good. Thanks, guys.
That's okay. Thanks. I appreciate that, because, you know, technology is a thing that not always is cooperative. So thanks for speaking up. If anyone else comes to a point where they can't see it, let me know. But it does show that I'm sharing. Humor, to the extent that any humor is used or attempted in this presentation, it is not intended to offend anyone or indicate that we take any of the topics lightly. It's just my attempt to keep it interesting. So, agenda today, we're going to be going through minimum wage increase and ag overtime. I always start every presentation talking about minimum wage, because that is where you get in trouble the most. The next new laws for 2025, notable cases, although I'm really only talking about one case today. Reminders, there'll be a section towards the end where I'm going to be talking about some existing laws and deadlines that are always a good idea to keep in mind and remind yourself. And then some ICE issues, because that is obviously a hot topic for all of us right now. And then any questions if you didn't ask your question during the presentation. And as Whitney said, if you have questions as we go along, please just put them in the chat, and Whitney is going to be monitoring them, so I can address your questions as we're going through the topic. All right, so the first section we're talking about is minimum wage. So as all of you know, the minimum wage for all employers in the state of California is $16.50. No more of this small employer, large employer on a statewide basis. Unfortunately, some municipalities still have it broken up that way, which is really frustrating. I'm sure all of you would agree that trying to keep track of stuff that is different, can be more difficult than it needs to be. But anyway, state's minimum wage right now is $16.50 per hour. This reflects a 3.5% increase from the year's minimum wage, based on the law's provision that allows this increase based on the consumer price index. So as you may recall, the law was changed a few years ago to tag the minimum wage to the consumer price index. The state looks at this every August and makes an adjustment. So if it's 3.5, if the CPI is 3.5% or more, it'll only go up 3.5%. And if it's less than 3.5%, then it's going to go up less than 3.5%. So around August is when they peg it for the next year. So it's always a good idea to keep in mind for that time frame. You need to update your minimum wage posters and other labor postings to reflect this. And you need to check your local minimum wage ordinances. So Napa Valley does not have any individual higher minimum wage ordinances, but if you have employees in Sonoma County or any other county in the state, you should be checking to see if there are cities that have higher minimum wages. So for example, Petaluma increases to $17.97. Santa Rosa is $17.87. Sonoma City is $18.02 for large employers and $16.96 for small. So again, they have that quirky thing, which is really annoying, and you have to make sure, especially if you're on that cusp around 25 employees, you have to be careful, make sure that you are paying employees correctly. So again, all Napa County cities use the state minimum wage of $16.50. Most of you are paying your employees probably more than minimum wage, so this is not necessarily an issue for you, but it's something you definitely should keep in mind, and particularly for your salaried employees. So that is the next slide here. This is where we see people fall into the most trouble. The minimum wage is usually pretty easy to keep up with, especially in this region that pays generally more than minimum wage. But the salary for exempt employees is where people can get into trouble if they've pegged it and then they don't pay attention to it, right? So you need to make sure that you're setting your minimum salary. That's your lowest salary that can be given to people. And this includes part-time people. So this is where I see sometimes people come into problems where they have an employee that maybe they're making $80,000 a year and they're going to go to work part-time. And I'm like, well, they're going to go 60%. So we're just going to cut their salary 60%. That's not going to be effective. That's not going to be lawful, because you always need to pay at least the minimum wage salary threshold in order to qualify to be an exempt employee. Doesn't matter if they work 1 day a week or they may work 7 days a week. So the salary for exempt employees in California must be at least 2 times the California state minimum wage for full-time employment. All of you know this calculation probably already, but you calculate using 40 hours a week times 80 hours per year, or 40 hours a week times 52 weeks, which is 2,080 hours a year. So this year, because it's $16.50 an hour, you multiply that by 2, and then you multiply it by 2080, it comes up with $68,640 a year for the minimum salary for all exempt employees. And the minimum salaries are tied to the state minimum wage, not the individual municipalities. Overtime. So for employers with 26 or more employees, overtime for ag workers has been 8 hours a day and 40 hours a week for a while. Starting this year, all ag employers will be at 8 hours a day, 40 hours a week for overtime. The phase-in for employers with 25 or more employees started on January 1st and will be completed. So it's completed here, and now we won't have to have this chart anymore, but we wanted to make sure it was reflected this year to make sure that everyone was aware that everyone is on the 8 hours a day, 40 hours a week. All right, so new laws. The first new law we're going to talk about is discrimination claims, combination of characteristics. This was SB 1137. It amends Section 51 of the Civil Code, Sections 200 and 210.2 of the Education Code, and Sections 12.920 and 12.926 of the Government Code. Starting January 1st, the list of protected categories has expanded to include traits associated with race, including protected hairstyles such as braids, locks, and twists, and victims of qualifying acts of violence for the employee as a victim or if a family member is a victim. The law now also clarifies that intersectionality or the combination of two or more protected traits is also protected. This may seem obvious, and it was obvious, but they wanted to put it specifically in the law. So from the legal standpoint, from my standpoint, I see this all the time, right? It's rare that you see a discrimination claim on one basis. Like I was discriminated against because I'm a woman. Usually you'll see I was discriminated based on my sex, based on my race, based on my physical illness. There's usually a list of them, and that's just defining that intersectionality issue. All right, the next law we're going to talk about is victims of violence. So, and this was AB 2499. It amended Section 214 of the Code of Civil Procedure, Section 48205 of the Education Code, Section 246.5 of Labor Code, and repealed Sections 230 and 230.1 of the Labor Code, and then added another section to the Government Code. It's rare to see us actually see laws repealed, so that's something that was different about this law. It didn't really take those laws away, it just folded them into the Government Code. So, and the Government Code is referenced there is FEHA, the Fair Employment and Housing Act. That's what that's referring to. So we used to have these separate labor codes, 230, 230.1, that dealt with leaves of absences that were available to employees that had been victims of crime and abuse and certain activities by employees who are victims or who have family members who are victims. Now, starting this year, those are included. It's updated to refer to victims as victims of qualifying acts of violence and provides for similar protections and accommodations from employers with more requirements for employers with 25 or more employees. The law also maintains that employees can use their paid sick leave for the reasons laid out in the statute related to seeking care or assistance. And the fact that it's in the under FEHA gives the California Civil Rights Division jurisdiction over these claims where they did not have it before. Disability compensation paid family leave. This is a minor change, but it's something that you should check in your handbooks. So it amends Section 3303.1 of the Unemployment Insurance Code relating to paid family leave. And again, paid family leave is not a leave that you provide. It's a horrible name, and I wish that it wasn't called this, but paid family leave is the state benefit, like SDI, like the short-term disability insurance that is through the state. Paid family leave is the benefits that you get from the state of California when you are on a qualifying leave from your employer. It's a very confusing name, and it causes a lot of problems for companies because people can assume that they're entitled to the leave even if they're not. So that being said, beginning January 1st, 2025, employers can no longer require employees to use up to 2 weeks of accrued vacation time before they start receiving paid family leave benefits from the state under the EDD's paid family leave program. So you should check your vacation and PTO, your CFRA, California Family Rights Act policies, and your PFL policies to remove any language requiring the use of vacation or PTO before receiving PFL. Paid sick leave for agricultural employees. So this was SB 1105, and it amends Section 246.5 of the Labor Code, which is the paid sick leave law. The paid sick leave law has expanded the use of paid sick leave to include use by agricultural employees that work outdoors to avoid smoke, heat, or flooding conditions created by a local or state emergency, including when the worksite is closed due to the conditions. So what is important, we got a bunch of calls about this when it first was talked about, but what's important in this is it has to have an actual emergency declared by the governor or a local authority for this section to apply. Doesn't mean that you wouldn't allow employees to use sick time for these conditions. Say you know, the weather is bad, it's too hot, so you send people home. You could always let people use paid sick leave. But if it's a declared emergency by the governor or a local authority, you're required to allow them to use it. It doesn't create new entitlements to paid sick leave, so it doesn't increase the minimum requirement, which is 5 days. It just increases the types of use that paid sick leave can be used for. Employer communications intimidation, SB 399. So this adds a new statute, section 1137 to the labor code. It's called the California Worker Freedom from Employer Intimidation Act. It makes it unlawful for employers to discharge, discriminate, or retaliate against or threaten to carry out such actions because an employee refused to attend any employer-sponsored meeting related to religious matters, political matters, or matters related to the decision to support or not support a labor organization or union. Now, although it talks about religious matters, political matters, it's really focused on being pro-union. So the law is intended to prohibit employers from forcing employees to listen to employer communications during union organizing campaigns. That's really the focus of this law. They did include in that religious matter or political matters. And given the last election, that was probably wise. There was a lot of dissension with religion and political speech going on at work. This was meant to make sure that employers were not trying to force their employees to listen to certain indoctrined views, regardless of what side of the political spectrum you might be on. But really the intended focus of this law is about unions. So it's really curtailing the employer's ability to discuss communications against union organization. Workers' compensation notice. This is sort of a behind the scenes law that you should be working on, making sure that your current workers' compensation carrier and your disclosures are correct. It requires employers to include information in notices related to workers' compensation rights and benefits that an injured employee has the right to consult an attorney for advice, and that attorney's fees will be paid from the injured workers award in most instances. So your form should have been updated from this, and your workers' compensation carrier should be helping you comply with that law. Driver's license discrimination. We've been getting some calls about this as well. So this was SB 1100. It amends section 12940 of the government code. It prohibits employers from including statements in job advertisements, job applications, or other employment materials that an applicant must possess a valid driver's license unless the employer can prove that it reasonably suspects driving to be one of the job functions of the position, and it reasonably believes that using an alternative form of transportation, such as biking or public transportation, that does not require a driver's license would not be comparable in travel time or cost to the employer. Temporary restraining orders and protective orders. This is about employee harassment, SB 428. This was passed a couple of years ago, and part of the law went into effect last year. This part is going into effect this year. It has to do with employers being able to seek restraining orders on behalf of employees who are experiencing harassment. This was part of the new workplace violence law that was passed last year. This portion of it allows an employer to seek restraining orders on behalf of employees for violence, or the old law allowed it only for violence. This is allowing you to bring it on behalf of harassment. Harassment in this context is defined as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person, and that serves no legitimate purpose. The course of conduct must be that which would cause a reasonable person to suffer substantial emotional distress and must actually cause substantial emotional distress. So this is not something that employers are required to do. This is something that employers may do. We had an example come up where an employee's former partner was upset about something that had happened at work and kept driving by the work and harassing that employee's supervisor. So they would come by and they'd start shouting things at them, and they were basically harassing them. Now, that employer could take several steps to stop that from happening, but one of them could be to get a restraining order so that person can no longer come towards the business or that individual employee to harass them. Pregnant Workers Fairness Act. Now, again, this was passed last year, went into effect. The EEOC published, and it's a federal rule. And normally, California laws on discrimination and employees' rights are generally broader and more in favor to the employee than federal law. But this federal law takes things just a little bit further on behalf of pregnant workers. So I wanted to make sure that we talked about it and made sure that you were aware of it and including it in your leave of absence discussions or your discussions with your employees who are pregnant. So it's the Pregnant Workers Fairness Act. The EEOC published its final ruling regarding the Pregnant Workers Fairness Act, and it became effective in June 2024. Even though this is a federal law, it expands the definition of accommodations for pregnant workers, including requiring employers to temporarily suspend the essential functions of an employee's position due to pregnancy. Now, we're all used to looking at, well, you can make accommodations so that the employee can perform the essential functions, but they're generally been required to perform those essential functions with an accommodation, right? It's never been able to say you just don't have to do the essential functions. If you have 15 or more employees, so this Pregnant Workers Fairness Act only applies if you have 15 or more employees because it's a federal law. We recommend adding a pregnancy accommodation policy to your handbook. So in addition, we've been adding it in after our lactation accommodation policy. So many of you have lactation accommodation policies to remind employees and their supervisors what the employee is entitled to. With regards to lactation, we figure this is a good place to put that. Sort of goes hand in hand. It's not a leave policy, so it doesn't go with leaves. It's its own accommodation requirement. I will give a caveat that it is a federal law. It is mandated and enforced through the EEOC. The EEOC is an arm and appointed by the executive branch, so we don't know if this will be rolled back. So far, it hasn't made the news that it's going to be, but we'll have to wait and see how it plays out through the next year or so. Where I've seen this come up and something that you should all be aware of is postpartum depression. This is where I've seen it the most so far. I've probably had it come up 5 or 6 times already this year, where employees have come back from their leave and they've had their full pregnancy leave, they've had their baby bonding leave, and now they've come back and said that they're suffering from postpartum depression and they need either additional leave, or more often than not, they want to continue working from home because of postpartum depression. And the law is doesn't really have a firm timeline on it. So there is built into the regulations, it's a requirement to accommodate, and it's per condition. So it's not cumulative, meaning that the employee could have been out for pregnancy disability leave, and the employee was out for baby bonding leave. Now they're back. Now they're suffering postpartum. That's a new condition. It could be 40 weeks of that particular period of time. So it's a little difficult to navigate, and it's so I encourage you, if you have employees that are in this state where they have requested additional accommodations, you had expected them back, you're not sure what to do, I encourage you to talk to your counsel to make sure that you're not inadvertently violating the Pregnant Workers Fairness Act, with the caveat, again, that I don't know if it's going to be enforced with the new administration. Next law is Indoor Heat Illness Rule. Cal OSHA has implemented a new indoor heat rule that applies to all indoor work areas that reach 82 degrees, with few exceptions. So the rule is similar to the heat illness prevention rule for employees who work outdoors, but now applies to employees indoors as well. Employers with employees who work outdoors or indoor work areas that reach 82 degrees or higher must create a heat illness prevention plan, provide cool down periods, provide cool water, observe employees as they acclimate, and train employees on procedures for compliance and safety. So as you look at your IIPP plan with either your workers' compensation representative or your safety trainer or consultant, you should make sure that you're wrapping in the indoor heat illness rules to your workplace if you have indoor areas that reach 82 degrees or higher.
Jen, we have a question about the postpartum and the 40 weeks example.
Yeah.
Could you repeat that example again and how it all ties together?
Yeah, so the law is long, so this is just a summary that I've provided to you here. But what the regulation has indicated is that the requirement for an employer to provide these accommodations is up to 40 weeks per occurrence. So that's why I was talking about the condition. So if they say they had really horrible morning sickness so that they couldn't get out of bed, right? And it was through the whole entire pregnancy. Well, under California law, you'd only be entitled to 4 months, right, of pregnancy disability leave, and then you'd have a reasonable accommodation. Well, that would fall under the Pregnant Workers Fairness Act. So that whole period would have been covered, the 40 weeks of the pregnancy. Then after they had the baby, if they had postpartum depression, that 40 weeks would start over again because this is a new condition. So, it's new. I haven't seen any cases on it. We're all trying to figure out how to comply with it, but just reading the face of the law, that's what it seems to indicate. So that's why I say it's really important to be working with your legal counsel to make sure you're in compliance. And again, with that caveat that we have no idea if the EEOC will be rolling any of this back. Does that answer the question? Okay, perfect. Okay, Private Attorneys General Act. So this PAGA has been a frustration for employers for probably a good 4 to 5 years. It's really heated up. It's created this cottage industry of lawyers, primarily out of Los Angeles, that have been bringing cases against employers. Some of you on this call, I'm sure, have been the recipient of a PAGA claim and have had to deal with it. AB 2288 and SB 92 amended the PAGA law, which is 2699. Effective June 19th, 2024, there were substantial changes to how PAGA actions can be filed and how employers can defend them, including, so this means anybody who filed a notice with the labor commissioner on June 19th or later. So since after that period of time, the named plaintiff can bring on behalf of employees who suffered the same violation only. So in the past, an employee could bring they could have worked for you for maybe 1 pay period, and they claim they didn't get all of their meal breaks. But they can bring an action on behalf of all of your state. They used to be able to bring an action on behalf of all of your state hourly employees in California for any labor code violation, even though they only suffered meal period. They say, regular rate violations, overtime violations, waiting time penalties, rest break violations. You didn't provide the proper standing. You didn't provide the proper reimbursement of expenses. Anything under the labor code you can imagine was thrown into this action for an employee that had worked for you for 2 weeks and suffered 1 violation. Now with the new law, the plaintiff can only bring an action on behalf of people that suffered the same violation. Still goes back 1 year. They still only have to have worked for you for 1 pay period, but they can only bring an action on behalf of people that suffered the same violation that they did. So that really has narrowed the scope of the actions. The next is it expanded the ability for employer to reduce penalties through various cure methods. So there's in the statute, there are various things that employers can do to minimize their potential penalties, which include trainings. They include instituting certain measures that would minimize any potential damages. It also reduced by 50% the penalties associated with weekly pay periods. So this was particularly maddening for vineyard employers, so employers of FLC. So FLC contractors or staffing agencies, people that paid on a weekly basis. PAGA's penalties are per pay period. So if you paid on a weekly basis, that meant that you had twice the number of potential violations as an employer that paid twice a month or every 2 weeks. So this new law recognizes that and cuts it in half. So now everyone's on a more even playing field, which is much more equitable. And it encourages employers to engage in ongoing training and auditing of wage and hour practices, which can also reduce penalties. So we're already seeing benefit, and I'll tell you where we're seeing the most benefit is with arbitration agreements. So if you have an arbitration agreement that has a class action waiver, you can enforce that individual employees to arbitrate their individual claims to determine what, if any, violations they suffered themselves, and then that would limit the PAGA action. So we're just starting to see that rolling out now. For the moment, the Private Attorney General Act cases are still primarily just being mediated and settled as quickly as possible to minimize the cost to employers. But we'll see how these new laws bubble up and maybe change the landscape of these laws, which have been really devastating for employers. Consumer Legal Remedies Act, this honest pricing law. So some of you on this call that have maybe that you do events or banquets, you have service charges, right? So this was a huge scare in the summer of what does this mean? How is this going to be applied? We have to change the way we do everything. They made a last minute adjustment to the law to exclude certain things. So starting July 1st, it's unlawful for companies to add a service fee or any other hidden fees, they called it drip pricing, to a customer's bill. All such fees must be included in the price of the item or service. So we've seen this, like if you've gone to go book a hotel now, or you've bought a ticket for a concert, something, you see the price now is higher because it includes all these fees that it used to not include. Taxes, government fees like sales tax and shipping can still be excluded from the advertised price and added to the bill. There are some guidelines there. There's a limited exception, and this is what was carved out after the law was implemented. There was a quick revision to the law, and it provides exemptions for restaurants and other food and drink providers, so most of you on this phone. And it applies to individual food or beverage items sold by a restaurant, bar, food concession, grocery store, or grocery delivery service, or by means of a menu or contract for banquet or catering services that fully discloses the terms of service. So you still have to disclose, it doesn't have to be included in the price, but you're going to have it disclosed what you're adding and what it's for. So all mandatory fees to be added to a customer's bill for such items as long as the mandatory fees are conspicuously displayed in the advertisement, menu, or other display for the items, along with an explanation of the purpose of the fees. Okay, Freelance Worker Protection Act. So most of you just have employees. Some of you may have contractors that provide you with services. Over the last few years, this has become a headache for you because of what's called the ABC law, which has really restricted your ability to use contractors lawfully. This is sort of another layer dealing with particular kinds of freelance workers. It basically adds 1810 to the Business and Professions Code. It places certain requirements on contracts with freelance workers, independent contractors, or consultants. We'll get down to the bottom of the particular kinds of independent contractors or consultants. A freelance worker is defined as a person or organization composed of no more than one person. So it's not, you're not contracting with Chatterbox, for example, you're contracting with an individual, whether or not incorporated or employing a trade name. So it's one person, even if they have an LLC or a corporation, but you're really contracting with that one person that is hired or retained as a bona fide independent contractor by a third party to provide professional services in exchange for an amount equal to or greater than $250, either by itself or when aggregated with all contracts for services between the same hiring party and independent contractor during the immediately preceding 120 days. So professional services are those services excluded from the ABC test under Labor Code 2778, such as marketing, artists, human resources, administrator, estheticians, manicurists, etc. So under ABC, there were certain people that said that were carved out. It said you can have a contract with these people. They won't be considered an employee if they meet the Borellos, the certain standards for independent contractors. And what this law is saying is, even if they meet those standards, you need to make sure that there are certain things in those contracts with those people. So the things that need to be in the contract is that it must be in writing and include the name and mailing address of each party, an itemized list of the services to be provided, the value of the services and rate and method of compensation, the date on which the hiring party will pay for the services and method that they will be paid, the date the freelance worker will submit for payment. The hiring party must keep the contract for at least 4 years, and the hiring party must pay the freelance writer on the due date, or if no due date is in the contract, then within 30 days after completing the services, and prohibits the hiring party from taking action against the freelance worker for asserting rights under the Act. And then it creates a private right of action for damages that includes attorney's fees and penalties. So what this means is that this contractor that you're contracting with has similar rights as an employee. You have to pay them within a certain amount of time. If they complain about their wages, you can't take any actions against them. And if they sue you, they're entitled to attorney's fees and penalties. So if you have contractors that fall under these parameters, you should make sure that whatever agreement you have with them complies with these requirements, and that you're just aware that there's a little more protection for them under this law than they otherwise had prior to it. All right, notable cases, which we're only going to be talking about one case, which is the Huerta versus CSI electrical contractors. So this one involved workers traveling to a remote solar installation, and they spent 5 to 30 minutes in a long line waiting to go through a security gate at the start and end of the day. The drive to and from the employee parking lot was another 10 to 15 minutes. They had a CBA, which is a union contract, a collective bargaining agreement, that provided for unpaid meal break, but they were not allowed to leave because of the isolated location. Employees sued for off-the-clock work. So the California Supreme Court was asked, so this bubbled up into the federal courts, and the federal court got this case and said, hey, California Supreme Court, we need you to give us an opinion about this law so we can rule. And they gave them 3 certified questions. The first was, is time spent on employer premises waiting in a personal vehicle to scan an identification badge and have a security guard peer into the personal vehicle compensable as hours worked? 2, is time spent on employer premises in a personal vehicle driving from the employee parking lot to the security gate, subject to the certain employee rules compensable as hours worked or employer mandated travel? And 3, is time spent on employer premises where workers are prohibited from leaving, but not required to engage in employer mandated activities compensable as hours worked when the time is designated as unpaid meal period under a collective bargaining agreement? So the answers were, because they were under the employer's control and the security search was for the employer's benefit, was not mere just presenting a badge, the time spent waiting to go through the security gate was compensable. The second part was a little more iffy because it was specific on the facts, so I'm going to skip over that part of it. But the third one is important to you because although the collective bargaining agreement provided for the unpaid meal break, because they weren't able to leave, during the meal break. It essentially became an on-duty meal period, and they needed to be paid at least minimum wage, even though the collective bargaining agreement had said that they didn't need to be. So the reason I'm telling you all of this is most of you don't have union workers, and most of you don't have long security gates to go through, but you could have very security measures or remote locations where employees have to wait. And why I have it here is just another reminder that anytime you are requiring your employees to wait for something that's for your benefit, whether it's for the next item to happen, or whether it's because they have to go through a security gate, or it's because they have to drive a long period of time to get to maybe a remote vineyard or something like that, you're going to need to pay them. So if you have any sort of quirky time issue with your employees, you should really be looking at it, because what I see as an employer, as a litigator, these off the clock time really are a focus for class actions. So even if it's 5 minutes, it adds up. So you need to be careful about making sure you're paying your employees for any time that you're having them wait. And the meal period, this comes up, it probably isn't necessarily applicable to a lot of your workplaces, but especially if they're working in a remote area and they can't leave, you have to think about that. And whether you should be just paying them, having an on-duty meal period and just paying them for that, that period of time. And an on-duty meal period doesn't mean there's a violation. It just means they're paid for that period of time. So again, check your procedures and make sure if you have any kind of quirky time requirements of your employees that might need to be taken a look at or discussed with your legal counsel. All right, so reminders of existing laws and deadlines. Go through this quickly. All of you are definitely aware you need to provide harassment training, harassment and abusive conduct training. So it's required every 2 years for all employers with 5 or more employees, 2 hours for supervisory employees and 1 hour for non-supervisory employees. The California Civil Rights Division provides free online training on its website. There are many resources through human resources consultants and through us or through other lawyers that can provide them if you wanted people to come on site and do in-person training. There's lots of different ways you can do it. It's just good to remember to keep it on your radar that you need to make sure that you're doing it. You're obviously, I think everyone has gotten to the point where they're doing online training for their new hires just to get it out of the way. But remember, if you've had employees for a long time, you need to make sure that you're swooping them up and making sure that they're getting the training every 2 years. New employees and new supervisors must complete training within 6 months of hire or promotion, and employees who provide evidence that they received training in prior 2 years don't need to retake training with new employer. This was something that came up a lot when it was first implemented. All right, Secure Choice Retirement Savings Program, CalSavers. In 2016, Secure Choice Retirement Savings Program was implemented. Employers with 5 or more employees must have private retirement plan, like a 401k, or enroll in CalSavers. CalSavers has a great website that you can go to. If you just Google CalSavers, it'll come up. You can find out, do some sleuthing, make sure that you've signed up for whatever you need to sign up to be in compliance. Employers with 1 to 4 employees can register with CalSavers and they have until December 31st, 2025 to comply. So this is the last, it's been going in stages based on number of employers of when you have to be compliant with this law. This is the last stage this year. Employers with 1 to 4 employees have this whole year to get in compliance. Everyone should be in compliance. If you have a 401k plan that's offered to everyone, that works. Okay, handbooks and arbitration agreements. Just a reminder, make sure your handbooks are updated for 2025. Take steps to do so as soon as possible. If you need assistance, contact us or your legal counsel or your human resources consultants, whoever you use, to make sure that you have all the compliant policies that you need. And we continue to recommend using arbitration agreements. I know that there's been over the years a lot of different opinions about arbitration agreements. We definitely recommend it, particularly for class actions. Now, if you only have, if you have less than 20 employees, for example, you probably don't need an arbitration agreement because you're not going to be at risk necessarily for a class action. But if you have 50 or more employees, and most of them are hourly, it's definitely a good idea to have a class action agreement waiver in your arbitration agreement. Okay, then what most of you have been having to deal with are concerns about ICE and what does this mean? There's so much fear and misinformation in the media about what's going on. We've put together some information to help people. The first is that your responsibility as an employer regarding immigration is very limited. So employers are not responsible for an employee's immigration status. Employers are required to complete I-9 forms demonstrating that employees have authorization to work in the United States. That's really your only requirement. It's unlawful to knowingly employ someone who is not authorized to work in the US, but you're not required to confirm that whatever documentation has been provided to you is authentic. So you're required to accept documents provided to you if they reasonably appear genuine. You don't have to go through any steps. You know, obviously, if someone slaps a photo on somebody else's document and it's obviously fake, you can't accept that. But as long as it reasonably appears genuine, you accept it and you fill out the forms. Your requirement is really only to fill out the form correctly and to document that you've looked at these documents and they appear genuine. There are risks under both California and federal law in taking action against an employee based on their national origin, citizenship, or immigration status. And frankly, you're at more risk taking action against an employee because you think they might have an issue with their national origin or citizenship or immigration status than a violation of the I-9 under federal rules. So from the beginning threshold question, your risk as an employer is very low in this time because you're really only subject to a potential fine if your I-9s are not in compliance. So you'll see a lot of things out there about doing an I-9 audit, which is always a good idea, but I wouldn't stress about it. Especially under this administration, it does not seem to be that they're very focused on employers. They're focused on the employees. So 3 reasons ICE may be at your work site. To conduct an I-9 audit with a notice of inspection, you'll have 3 working days to produce I-9 documents for inspection. This, I have not seen this 10 years maybe. Maybe, I don't know if any of you on this call have had an I-9 audit, had someone come in and say you're going to be audited. It doesn't happen very often. And again, like I said, I don't think the administration is really focused on that this year. But what you can do to get yourself ready is just do an I-9 audit. The ICE has a lot of good resources for you about that. You can go to employer guidance for ICE or I-9 compliance. I think it's like I-9 compliance for employers. There's a handbook. It's very helpful. Tells you what to do, what you can and can't do with your I-9s. The other reason ICE might be on your work site is to conduct a workplace raid, but only with a judicial warrant. And they may be to detain a specific person, but again, only with a judicial warrant. So you've seen a lot in the news about they can only come onto your property if they have a judicial warrant. So judicial warrant is issued by a court and signed by a judge. I have an example for you here that we can look at. So this on the left is a judicial warrant. You can see it's from the United States District Court. It's issued by a court. It's going to have a court case assigned to it. It's going to be signed by a judge. It's going to tell you what you are required to do and when. On the right is a sample of an administrative warrant. This is not signed by a judge. Oops, this is not signed by a judge. It's not a court. It's from an administrative agency. So in California, you have specific laws that are going to be prohibiting you from allowing ICE to come into your non-public areas without a warrant. So you're sort of in this delicate position where you need to comply with federal law, but you also need to comply with California law. So let me go to the next slide, steps to take in preparation. So again, we talked about conduct an internal I-9 audit. If you have questions about that, you can look up, Google the I-9 compliance help for employers directly yourself, or you can talk to your legal counsel or your human resources consultant about that. You'll want to designate a point person in charge if ICE shows up. So this is just protections. Now, I have not, maybe some of you on this call have, but I haven't heard of any actual ICE enforcement in our area. But in preparation, you would want to designate a point person to be in charge if ICE shows up, and all questions should be funneled to that person. You want to inform all employees that they are not authorized to give ICE permission to enter and instruct employees to direct ICE personnel to the designated person with authority. Now, there's a distinction between private areas and public areas. So ICE is allowed to go to your public areas. Everyone can go to your public areas. We're talking about your private areas. So you need to clearly mark private areas that are not open to the general public with no trespassing or private property or similar signs. So, you know, maybe you have a tasting room that's open to the public, but any back rooms are going to be private property. You want to make sure that your warehouses and your production areas and your vineyards are marked private property, no trespassing, that they're not allowed to go on there without your permission. You do not ask employees about their immigration status or provide legal advice as to their rights. So this is where really we're getting the most questions is what can we do to help our employees, right? They're scared, their family members are scared. What can we do to help? And there's lots that you can do. What you don't want to do is get into a discussion with them about their immigration status, right? You don't want to know that they're not here without authorization, because as soon as you know that, you can't continue to employ them. So you don't want to have a discussion with them about their own immigration status. And a lot of what I've been hearing is a lot of people are scared for their family members or their community. And they may be scared for themselves, but you want to provide general information. So you want to provide either a memo, or maybe you have someone come in and speak to them, to all employees, and give them informational resources. A good resource is the National Immigration Law Center. It's there's a link here. Obviously, you can't link on it to this, but if you type up National Immigration Law Center, it has a wonderful resources. It gives you information that you can provide to employees. It gives you information for yourself as to what you can tell employees. I just caution you not to provide legal advice yourself. You are not lawyers, and you don't want to be seen as assuming that someone isn't here lawfully. So again, going to that, balance that you have to take as an employer. You don't want, I had one client ask me if they could hand out red cards. And red cards, as most of you know probably, are their cards that have been printed on red paper that basically tell are meant to be handed to a law enforcement officer that provides that you are exercising your right not to remain silent. You're exercising your Fourth Amendment right to remain silent, that you are not going to speak, and it's giving people their rights. And I was worried they wanted to hand them out to their employees, which is nice to be able to provide them. I just caution, don't go and hand them out to people, make the assumption that they aren't here lawfully, right? So you need to make sure that there's no inadvertent discrimination happening at your work site. And you don't want to foment fear, right? You want to just provide information, provide a safe place for them to go to work, and take steps to make sure that ICE isn't going to come into your private areas.
We have a quick question in regards to the tasting room.
Yeah.
If the tasting room and the property is by appointment only,
okay,
does that change its status of private property or no trespassing?
Yeah. So if it's by appointment only, it's not open to the general public, but I would go a step further and make sure that you have some kind of, by appointment only, that they can't just walk in, right? So I think there's varying degrees of that. Some wineries have gates outside that you need to buzz in. Some just have a sign and people can walk in anyway. So you're just going to want to make sure that you've taken steps to show that it's private.
Great. Excellent job, Jen. That was wonderful.
Thank you. Any other questions?
I will say a lot of information and a bit overwhelming, but
Yeah,
all really
always
important
is.
stuff. And the stuff at the end about ICE and how to handle that was incredibly educational and informative. So thank you very much.
You're welcome.
We'll go ahead and open it up to questions. Does anybody have any questions? You can either drop them into the chat or you can unmute yourself, either way. Okay, always a good sign when we have no questions. Either we're overwhelmed or we feel good. So
All right.
I'll take that we feel good. So thank you for joining us, Jen. I see your contact information is right there. Any final words to close us out?
Nope. I think, everyone, from my standpoint, everyone's trying to do their best, and that's really all we can do. So just continue to be aware and reach out to people if you have questions.
Awesome, Jen. Well, thank you so much for joining us today.
Welcome. Thanks for inviting me.
Absolutely. Yeah, we're so happy to have you. Appreciate your time. And everyone, thank you so much for joining us, and we'll see you around the Napa Valley. Have a wonderful day. Bye-bye.
Bye-bye.